with the recording.
Oh,
So
hang
hi,
on.
yeah, okay. Hey
Right.
everyone, and thanks for coming out to this is the last of the scheduled Tort Law and Social Equality Project Speaker Series events. So we're finishing with a bang. We're welcoming Sam Beswick, who's a professor at UBC Law School. He's a private law scholar with research interests in torts, unjust enrichment, and limitations and remedies, and many aspects of private law and civil procedure. Um, some of his recent work in research and pedagogy is focused on open access research, and that will be the subject of his talk today, opening up tort law, marking the launch of a common law torts wiki that he has been working on at UBC. So Sam, you'll have about 45 minutes is our usual for the talk, and then we'll open it up for Q&A going up until 1:30 after that. Please take it away, and thanks for joining us.
Thanks very much, Anthony. Thank you, everybody, for coming along on your Friday mornings or afternoons, depending on where you are. I'm going to share my screen for the presentation. Um, and just, if you can bear with me. So I'm going to keep things fairly informal and step you through a project that I've been working on for the last um, largely for the last 2 years, but influencing my work since I began teaching at UBC's Allard School of Law. Um, it's a project that's summarized up in this brilliant poster that was put together by one of my research assistants and soon to be graduated JD students, Claire Katona. And a project that I worked on with several students who are identified on this poster as well. And the project's all around the theme of bringing open access to tort law, opening up tort law, and placing tort law in its social and current context, particularly in Canada. So what I'd like to do with this presentation is give a bit of a background as to what motivated me to develop these resources. I'm then going to step through a casebook that I started to develop a couple of years ago and have been improving and working on each year, publishing updates to. And then I'm going to introduce a wiki, which is the new project that's been launched recently, and this is something of a launch event for that, which is a tie-in commentary for the casebook readings that I've set out on CanLIIDocs. So this project, the Wiki project in particular, is supported by UBC Teaching and Learning Enhancement Fund. I received a grant to work with students to develop this project, and the specific grant that I received to do this is a grant paid for by student fees, and it's meant to support projects that employ students to develop open access resources for the benefit of students. And so that's really what was behind all of this project. And it was it was a fun exercise for me. I think it was a fun exercise for the students. It was a bit of an experiment, and it's something that I think we'll be able to build upon in the years to come as well. All right, so a bit of background as to why I set about going down this path of developing open access resources, and in particular, an open access casebook. I joined the Allard School of Law in the summer of 2020, and after many years of study, I had to set about teaching my first course in torts. And as I did that, there were a few influences on my approach to the subject, but I wanted to highlight three for the purposes of this presentation as to why I just ended up going down the path of developing a new and certainly in Canada, different kind of torts casebook. So one of the influences on my approach was my own law school education in New Zealand at the Auckland Law School. So what I was used to in learning my common law subjects at Auckland were casebooks that were generally photocopied, spiral bound resources, fairly stripped down resources that were edited down for relevance and updated each year, but not commercial casebooks, not anything that had any particular resale value. or any extended life beyond the year of that course, because there'll be a new version of it next year. I think one of the benefits of having these more hodgepodgey, if you like, case books, was that we're encouraged to make them our own in the learning. And so we're really encouraged to highlight up the pages. They weren't going to be useful for future students, so we can note up in the margins, highlight. And I actually remember my torts professor, Professor Rosemary Tobin, as she would teach torts, she would walk up and down the aisles of the classroom. And if she spotted pages or casebooks that hadn't been highlighted or marked up, she would draw attention to that student, suggesting that they hadn't done their readings. And I suspect it might have encouraged some students just to randomly highlight pages. But I think it made the point that it was about kind of making the casebook your own. And so that was the experience that I brought to Canada when I was coming here, was this idea of a casebook is a thing that you just scribble all over. The second influence on me for developing this was my colleagues. When I started teaching tort law, we have 4 tort law streams, and I discovered that my other colleagues at this point at the law school were tending to teach from reading lists as opposed to established casebooks. And so these reading lists tended to be sort of long syllabi, usually linked to CanLIID cases, often with descriptions of kind of which paragraphs to read, or noting particular readings, but not put together in any one particular bundle of resources. Now that obviously has advantages, because it means you can tailor the resources to the professor's particular interests. It's obviously it's obviously financially accessible for students, but I think it has disadvantages too, in that the reading list approach doesn't I gather you are directed to, say, read specific paragraphs of the case. They might spend time editing out those paragraphs from the longer judgment of a Word document of the judgment in order to understand, also in order to kind of condense their readings. And there's also the issue that on the list approach, as opposed to having a physical case book, that you can't be in the classroom and sort of literally all be on the same page as you're working your way through. And that was something that was important to me, because I wanted to teach torts in a Socratic kind of way, where we're really looking at the words of the judgment, working our way through, trying to understand what's going on. And so I wanted a resource where we can readily be all on the same page in class. And then the third influence on why I decided to set out my own, sort of chart my own path in developing a torts casebook was the time that I came to teach torts at UBC. I joined in the summer of 2020, and at that time, the big event of the news, apart from the pandemic and related to the pandemic, were the George Floyd protests. And suddenly, this sort of obscure US doctrine called qualified immunity was in the news. And it was a doctrine that I was aware of from my years studying in the United States. And it was something that I'd always found kind of foreign to my understanding of the principles of civil liability, particularly in common law countries. And so I was thinking about this doctrine as I was thinking about tort law, and it got me thinking about, well, why should students care about tort law? Why should students care about civil liability, particularly in this context? And then at about the same time, Professor Neil Foster from I think at ANU circulated on the obligations listserv the High Court of Australia's judgment in the Benzaris and Northern Territory case, which for me outlined an extremely important counter approach to understanding police liability. So the Benzaris case is a case that was decided in 2020. It's certainly a challenging case. It involves claims of common law battery that are brought by 4 Aboriginal Australians who were incarcerated in the youth detention centre and who were tear gassed by officers while they were sitting in their cells, not because of anything wrong that they were doing, but because it was necessary, or sort of it was a side effect of the officer's decision to subdue another inmate, a man called Jake Roper, who was causing a disturbance in the detention centre. And the case was fought all the way to the High Court of Australia, and it raised fundamental questions around the tort of battery, around the defence of necessity, and in particular, I think for me, around the principle of equality under the law, the idea that police officers, prison guards, the Prime Minister should be expected to be held to the same standards under the common law as anybody else. And that's actually what the High Court of Australia held. They upheld the battery claims. There's a very interesting concurring judgment by Justice Gageler around the scope of the defence of necessity in that case and dismissing the defence of necessity in that case. And for me, I think the case really illustrated sort of a contrast to the narrative of qualified immunity that we're seeing in the United States. And so all of that was sort of percolating for me in 2020, and I decided to integrate it first into an opening lecture in my torts class, sort of pitched around to the students as, well, why should you care about tort law? And then it became more of a theme of my torts class, this theme of the rule of law, this theme of the idea of equality under the common law. And as I was teaching my course the first time around, I found myself supplementing my materials with more cases from around the common law world that I thought were particularly important, that either illustrated this point or illustrated other points that I thought were significant to learning and understanding tort law in Canada. So all of which is to say, I began collating my own materials. I collated them based around sort of two particular themes. The themes, I'm not sure if it can be read on the screen here, but I sort of have 5 themes that I suggest influence my selection of cases and the materials that I focus on. But 2 in particular was this theme of equality under the law, equality of public officials under the common law and applying the same rules to them as to everybody else. And then a second theme of the common law being a dialogue between judges, not just between judges over time within the same jurisdiction, not just between judges in Canada, between different provinces, but also a sense of the common law being a dialogue across common law jurisdictions, which was something that was very familiar to me learning in New Zealand. You'd very often be learning cases from Canada, from the UK, from Australia, from other jurisdictions to influence or illustrate points of law in my jurisdiction. So initially, it was just going to be an in-house casebook, but then CanLIID sent out a call for resources under its authors program, and I got in touch with them, and we developed what is now on CanLIID. Now, I should say that the casebook on CanLIID is not meant to be equivalent to a commercial casebook. It doesn't have the comprehensive commentary or research notes that you find in a commercially published casebook. It's not meant to be a research stepping off point. It's very much designed solely as a teaching tool and something to be that I personally find useful in the classroom for reading through and focusing on case law in particular. So why go with open access? Well, there's a few reasons before I dive into the casebook as to why I decided to go down this open access path. One, I think it just is particularly well suited to the teaching of law, and it's an important kind of really constitutional point. I particularly like the drafting of Canada's reproduction of federal law order, which states that it is of fundamental importance to a democratic society that its law be widely known and that its citizens have unimpeded access to that law. And I think initiatives like CanLIID and other open access initiatives are trying to make this point real for students of law, but also for society more generally. Open access has also been a particular focus at UBC. There's grants that have been set up in order to encourage the development of open access resources. And I think the platforms are just excellent. And CanLIID, the wiki platform that I'm going to demonstrate, they're just extremely user-friendly. They're extremely accessible for students with disabilities. They're financially accessible. They're flexible to work with. They provide a lot of editorial control, and they make the law and the case law and the insights available to the public more generally. If people are interested in the topic of open access publishing in law, in particular in Canada, Professor Jamie Baxter at Dalhousie has some good scholarship and projects on this as well that can be followed up with. All right, so that's the background. So I'm going to move on to demonstrating a few of the features, kind of the design features of the casebook that I've been developing with CanLIID, and then I'll get into demonstrating the wiki and how that works. So this is the casebook. It's readily available on CanLIID. The cover image was designed by a previous student of mine, Lorraine Sans-Regret, who's a very talented artist. And in fact, if anybody is interested, you can see some of her, if it will load, always the way. Here we go. Some of her other art here can be purchased. So there's the plug there. So the design features that I really like of CanLIID is, first of all, the flexibility of it and the ability to kind of digest the materials in multiple formats. So there's obviously the online CanLIID format, which is very scrollable. I often bring this up on my phone when I want to check out something on a case, and it's very easy to read on a phone. It can be downloaded in EPUB for an e-reader. It can be downloaded in PDF format to be printed out. I always get our copy center to print out copies so that I have this physical version, which then I do highlight and scribble all over throughout the year, and I encourage my students to do the same. It's modular. You can if there's a particular topic that you're interested in, but you want to integrate it with another casebook or with other teaching materials, you can choose to print out just sections or just focus on sections without being sort of bound to kind of using all of the materials or none of them. I'm gonna cover some sort of what might seem like trite features, but for me personally, I find them extremely helpful in the classroom. So one is one thing I noticed, which I found I find challenging with other casebooks. And I actually think paragraph numbering when you're in a casebook learning a judgment is extremely helpful, both for understanding how much of text has been edited out of that judgment, as well as for being on the same page in the classroom, rather than saying, well, we're halfway down the page, 3 lines up, and just say paragraph 14, Lord Reed, what does he mean by this? And so this is demonstrated by the Hedley, Byrne and Heller case here in the casebook. And every time I've edited out text, I might be accused of being too heavy-handed in editing text sometimes, but I put in these dinkuses, that's what they're called, to illustrate where text has been edited out. And I think the paragraph numbering also just helps to show how much the reading is jumping around. Other features, so there's each reading in the casebook just has direct links back to the original, whether it's on Bailey or CanLIID, which are most of the sources in the casebook. And there are also other features in the casebook itself that link to other resources. So each resource is followed by these reflection questions. Sometimes this isn't going to show up well on the screen, but those reflection questions might link to other suggested material or readings, which then links to those readings. Each section of the casebook also links to other suggested readings or just potential readings on the relevant topic as well, whether that's podcasts, journal articles, or others. And the idea being, if you're teaching from the material, you might want to dive further and assign particular sections of these articles. Or if you're a student just interested in a topic, it's a launching pad into saying, well, what scholarship is there on this particular topic? Another feature of that I think works really, really well with CanLIID in particular is the idea that you can cross-reference all the cases, so that when you're reading a case, in my class we always cover we do a couple of classes on negligence causing pure economic loss, one on misrepresentation and one on the Winnipeg condo shoddy goods category. And it's always very satisfying to me when we get to reading Ontario and Maple Leaf Foods. Because as we go through, we can see all of these cases that are cross-referenced directly in the casebook that you can link to, and we'll take you right there. And all of them we've encountered by the time we reach Maple Leaf Foods. So we encounter Palsgraf, Livent, Mustafa, Childs, all of these cases. And I think it just sort of really illustrates the coherence or integration of the case law as sort of a bigger whole in torts, when you can literally see, well, these cases are appearing throughout the casebook as well: Clements, Babstock, and others, and obviously Cooper and Donoghue and Stevenson. So I just find it very useful from that approach. Another feature that the torts professors in the room might have spotted is the way that I go about illustrating the tort of negligence. So one of the my approach to negligence, also informed by the way that I was taught, was to split out the topic of negligence into kind of two categories. First, outlining the basic principles of the 5 elements of negligence: duty, breach, damage, causation, and remoteness. And only after we go through the sort of exploration of the foundational principles, or the 5 elements, do we get into what I generally refer to as sort of these difficult categories of negligence: negligent infliction of mental suffering, negligent misrepresentation, shoddy goods. And the reason for that is that I think it's very helpful to have that before we get to a subject like negligence causing pure economic loss. Very helpful to have that grounding in, say, principles of remoteness before we start to ask the question, well, why is pure economic loss in a case like Winnipeg Condo, why is that not property damage, for instance? So what that means is that in the broad section, in the basic principles section, some of the principles cover a lot of cases fairly briefly. So under breach of duty of care, for instance, where you have to ask 2 questions, you have to ascertain the standard of care and then apply the standard of care. There are a number of kind of classic illustrative cases of this point. You obviously can't read all of them, but what you can do is read the important excerpts from them. And so in my class, we cover, obviously Bolton and Stone, Miller and Jackson for these points. And as we go through the students are getting the direct illustrations from the cases, rather than a sort of a summary of the cases, but I think enough of an illustration that it sort of encapsulates the point that's going on. All right. And then finally, I think the benefit of having this sort of CanLIID vision of the casebook is it's just readily updatable. So in Canada, there are a couple of tort cases that we're all hanging out for. The Alawalia judgment is one, for instance. When that comes out, I'll be able to integrate this into the casebook very readily. There's another case that's just been granted leave I've just seen on causation, which I'll be able to integrate into the causation section. It's called Hemmings and Padmore. And so the ability to kind of integrate that and build upon it very, very quickly and to amend the readings, I think is just a real advantage of the simple platform that it's using. But of course, there's something missing from this, and that's the commentary. There are reflection questions. There are links to other resources. There's sort of the idea is it's a springboard into other resources that are out there, other articles and books that can be accessed online, but it doesn't really engage with the commentary on those. And so that's what this wiki commentary project was designed to do, was to develop a commentary that integrates or sort of complements the readings in the casebook, that can be updated as the law develops or as sort of particular points become more salient, or particular particular points of interest come along, and that provides a broad overview of the readings that you just don't get from having excerpts of the readings here. So here's the here's the wiki. And I really like the wiki format as kind of a more informal commentary to complement the casebook. Again, the idea of this wiki isn't to be a textbook to replace other textbooks. It's not trying to do that. If anything, it's more like a hornbook, kind of a brief overview that integrates and links in with the primary sources and with other relevant secondary sources. It is interactive in a way that just a physical book isn't. And so the benefit of the wiki platform is you can embed, for instance, podcasts and YouTube videos, which are generally licensable to be embedded for use, and then link back to the original source. You can reference news items. You can hyperlink to all the sources. You can integrate quizzes and other interactive features into them. And then the wiki itself also has a large open license repository of pictures that can be brought in to illustrate kind of the various points. So the Common Law Torts Wiki, it's navigable by this side index, which lists out and categorizes all of the pages and is structured in a similar way to the casebook is structured. So you'll see, for instance, the way that I structure out my approach to negligence liability with the 5 elements of the negligence tort first, followed by these sort of categories of negligence that break down in different ways. The idea of the wiki is to allow students sort of the flexibility to dive into the material in their own time, or for me to assign particular topics where I want to dive deeper on a topic. So let me sort of demonstrate, for instance, trespass to the person, the first topic that I generally cover in my class. We go to the trespass to the person page. What do we find? Well, you get an overview, a definition of what the torts of trespass to the person are, citing back to a hyperlinked journal source. Get an overview of the basic concepts and features of the torts. You get tables to demarcate the elements of the tort that have people of slightly different variations of the wording of how the tort of battery, for instance, is defined. Again, hyperlinked back to case law. In the interactive part, or sort of the society part, is integrating sort of relevant news items relating to the cases that the students might be reading in class, to illustrate sort of the bigger context of what's going on here. So, for instance, we read the Benzaris case in class, this case of these 4 detainees in this Northern Territory youth prison, where their claims of battery were upheld. Well, this is just one part of a larger story in the United States, which was in many senses a scandal that resulted in a Royal Commission inquiry that led to a lot of media interest. And what the wiki does is integrates a news interview with Jake Roper, who was one of the who was the person who kind of instigated, I suppose, or was the reason why this case even ended up at the High Court of Australia. And I usually play in class a minute or two of this interview, because what it highlights to the students is that the cases we're reading are not just sort of fun or interesting stories about how the law applies to certain circumstances. They are stories about people's lives and how their lives have been impacted. And I think by integrating these news items directly into the wiki commentary, it sort of helps to bring home the point. Again, another interesting one, that's a story that took my interest, was this judgment from Australia, where a family court judge was successfully sued initially for the tort of false imprisonment, and there was an excellent podcast covering the context of that case. It was subsequently overturned on appeal, but again, we can learn about the context of it and then use it as a springboard for understanding and thinking about sort of the principles that underlying the torts that we're discussing. Finally, we scroll all the way down. We can see the relevance to criminal law. We find some discussion questions, placing in context. Again, some of the concepts that have long been in the common law, but placing in the context of their relevance to today. For instance, questions about the kettling of protesters, something I've done a little bit of writing about in a recent article. And then finally, some interaction. There are some quizzes. The quiz database is probably will need to be built up in a future project, but at least the idea is it gives the students some opportunity to kind of test their own understanding of the materials. So, which statement best describes a voluntary action? Well, we can let's hope that I get this right. There we go. I got 1 out of 1, and we can work our way through. And again, I'll illustrate perhaps more briefly another page. Intentional infliction of mental suffering is a page that I think is particularly nicely done. It illustrates sort of the origins of this kind of unusual tort that begins with Wilkinson and Downton. It integrates a video that's from YouTube, again hyperlinking back to it. Sets out the elements, and then it works through and discusses, well, how has this tort evolved over time into what we now call the tort of intentional infliction of mental suffering? We can see the Supreme Court of the United Kingdom provides their handing down of judgment, again, directly on YouTube. We can see the elements of the Prinzo test, and we can see the relevance of the tort to people's actual lives. So Fitzpatrick and Owens, for instance, which is one of the classic illustrations from Ontario of the intentional infliction of mental suffering tort. And the resources link back to, in this case, a National Post article interviewing the people affected, and again illustrating that these cases are not just interesting stories. These cases are people's lives. I think that's important as well, because it then helps to encourage the student to think about, well, why are people bringing these torts cases, especially in cases where perhaps the damages that are awarded in the end aren't particularly high. And the answer that I suggest, or that we explore in class, is that, well, maybe they're not just bringing tort cases to get compensation. Maybe they're doing it to make a point, to vindicate their rights. And those sorts of discussions and those sorts of thoughts lead us to then think about all the theories that are underlying tort law and what tort law is actually about and why it exists. Okay, so, and here's that page. Oh, I hate quiz questions with a negative in them, so I won't even attempt that one at this point. All right. Again, I'll illustrate a couple more pages, and then perhaps I'll finish slightly earlier than time allows, and we can discuss anything that's of interest to people. Again, I highlighted sort of my approach to teaching the tort of negligence. You can see, if you click on the negligence tort overview, you get a sort of a broad overview of the tort of negligence and the elements that link to their respective pages. And then as we jump into, say, breach of duty of care, well, now we start to get some context. And here we are again from a tort law and social equality theme perspective, given the group that we're meeting within. We come to breach of duty of care, and we can see immediately encounter podcasts and a lecture given by Professor Moran, scrutinizing and questioning the objectivity of that reasonable person standard, which is some discussion that we have in my class. And I think having a podcast right there, encouraging students to say, when you're on the bus, just have a listen, watch the video, come to class. What did you think? It just helps to integrate, I think, the questions and themes that we discuss in a way that's accessible and sort of different through different mediums, not just through reading. And the resources are out there, and people have provided them. So all this is doing is really just acting as a springboard into those resources, collating them together rather than having them scattered across YouTube and other sources. It's Professor Goldberg. So we work our way through. And again, linking to news stories and explaining what it means, connecting up to these readings that we have. Okay, the severity of gravity of risk. Now that we've sort of read through some of the primary materials, well, how does that relate to the concepts that you're supposed to be getting out of those materials? And so that's the overview. Those are the sort of the overview of the 5 torts. And then I also set out these categories of negligence and suggest that they help to illustrate how we went from Donoghue and Stevenson and Palsgraf and these other cases to a reasonably sophisticated and certainly complex understanding of how the concepts of duty and breach and damage and causation and remoteness play out in different circumstances, whether it's product manufacturers or hosting commercial or social gatherings. And I think it's helpful as well. I'll illustrate with the page on negligent treatment of Indigenous children, given again the theme of tort law and social equality. I think it's helpful to have that overview and sense of the 5 categories of negligence before we dive into these more difficult topics where the issues are maybe challenging on a number of fronts. And so on this topic, for instance, we encounter the context of residential schools, we encounter the context of the 60s scoop. And one reason for demarcating these as a distinct category that one encounters after covering the 5 elements of the tort of negligence is that it helps better place in context the obstacles that these sorts of claims encountered through tort litigation. So this page, for instance, it provides some context, a springboard into, say, a podcast on the 60s scope. It also provides an overview of the types of tort actions that have been brought in the residential schools cases, the types of arguments, the difference between direct liability arguments and vicarious liability arguments, the complexities of class actions that, again, connects to the class actions page, the significance of settlement agreements and why parties might have settled these claims, and then placing in context why, related to why parties might have settled, the obstacles that tort litigation has presented, particularly in the residential schools litigation context, right? The obstacles to establishing a duty of care, the evidential obstacles to proving breach, the difficulty of that's been encountered with factual and legal causation, for instance, something that Professor Roach has written about in an article in the Toronto Law Journal, and the difficulty of limitation periods and others. And so with that kind of that broad overview understanding that you get by working your way through the 5 elements, I think it provides provides an opportunity for a bit deeper understanding as to why those elements might can be difficult to grapple with in different contexts. All right, how are we doing for time, Anthony?
Right on time. You can take I think an extra 5 minutes. We started a bit late, but that's your call. Or
all right, I just want to show off 2 more pages, and then we'll
please up. Feel free.
So one page, I like to start my discussion of negligence liability with a discussion of a world where there is no negligence liability, a class on no-fault compensation schemes. Again, coming from New Zealand, where tort liability has been replaced in the personal accident realm by a comprehensive government system. But it's a very complicated and convoluted discussion, and not something that and could be an entire course in itself. So how do you cover it in one class? Well, I think setting out in a wiki format a very brief overview of what this is and how it differs from a tort system is helpful. And so here's the page on no-fault compensation schemes, which again links to some visual overviews. It discusses briefly the idea behind workers' compensation schemes. It introduces a topic particularly important in British Columbia, which is a new regime of no-fault vehicular insurance that was brought in a couple of years ago through ICBC that has proven to be very controversial. Um, and, and that I think that has made it into the news. I actually play some of these news clips in my class because they interview users of the system. They interview lawyers representing both plaintiffs' lawyers as well as lawyers representing the ICBC, and they're quite just within a few minutes. They really help to frame and place frame the argument and the trade-offs that you encounter between operating society under a no-fault compensation scheme, as opposed to dealing with accidents through the tort system. And then again, it connects back to connects back to other contexts as well, the 60s scoop settlement, and interviews with people involved in that, discussing whether they thought, for instance, the settlement there and the principles of no fault that were integrated into the settlement was the right trade-off to be made in that context. And all of this content within, I think, a fairly brief and digestible page that one might read on the bus on one's long commute to school or watch in one's own time. And then finally, I mentioned before the idea of putting this resource together to encourage students to question, well, what's really going on here? And again, I generally dedicate one class or one or two classes to tort theory. And so how could one possibly cover tort theory in a single 50-minute class? And so I've developed Professor Beswick's overview of 10 theories of tort law, which I recognize people might quibble with. But again, the idea is to encourage students to think about the different perspectives that scholars hold in this area, and not just to see tort law as about compensation or as about deterrence or as about one thing. And I think the wiki helps, at least it's designed to encourage students to encounter, to grapple with or encounter these materials in a more accessible way than reading a full journal article, but then of course linking directly to those journal articles. So under critical theories of tort law, we get a shout out to the Tort Law and Social Equalities group. And I integrate this metaphor of the quilt. I quite like this metaphor that Professor Peter Kane uses, and I'm sure other people have used too, is to, if tort law is like a quilt, well, what does this mean from the perspective of tort theory? And I offer at least my own view as well. It means we can see the quilt in quite different ways, right? We can see it as an instrument, a thing to be used, a thing to have a picnic on. We might see it, I refer to sort of constructive theories of tort law to integrate kind of the rights-based and justice-based theories that purport to understand tort law sort of within its own internal perspective. The critical perspective, and of course, and what I refer to as the reflective perspective, the perspective of people like Peter Kane and Jaden Stapleton, which rejects the idea that tort law is about any one thing, and suggests that we can only really understand tort law by understanding its development over time and its complexities for all they're worth. All right, so the wiki is a starting point. It certainly is not perfect. It will be refined over time. Fortunately, in tort law, the standard is not perfection. But I think it's interesting. It's been a fun project to work on with the students. I think the students have appreciated, enjoyed it. I have appreciated, enjoyed it. I hope others do too. There are ways to contribute to it if anybody's interested in doing that. And I'll say that what this journey has done for me personally as a scholar, as well as kind of it forced me to kind of grapple with the subject that I'm passionate about, that I've taught, but it's also given me ideas for my own scholarship. So that the Banzaras case, the theme of the rule of law, has inspired several articles that I have written and continue to write around that. And I'm not sure that I would have done that had I not decided to just try and make a stab at creating my own torts casebook, as opposed to using other materials. So there it is. And I'll pause there and yeah, I'll be interested in discussing people's thoughts on this project. Thank you very much.
That's great. Thanks so much, Sam. And I think A really quick question is like, if I want to teach torts, am I allowed to use the tort textbook for my own class? And right,
Yeah,
so that's a bill I would really love to do that.
yeah,
So
that's the idea.
yeah,
That's
makes
the
sense.
idea.
So I do have other questions, but I'll open it up to the audience and starting with Melanie.
Thanks, Sam. I actually just wanted to say I don't have a question right now, but I just think this is a formidable achievement and like a complete gift to the community, both of scholars and of students. So I'm totally impressed
Thank you.
by this piece of work, and I definitely am going to be using it more and more. So thank you for sharing it. Thank you for doing it.
Thank you, Melanie.
Zoe?
Yeah, I'm going to steal some of your stuff too. But it's a question like, so you started off talking about the importance of like the physical copy of the textbook and make use of make the casebook your own. So so do you provide bound copies for your students?
Yeah.
Yeah. Okay.
Yeah. So yeah, thanks. Sorry. What I do is the actual PDF of CanLIID is I think 950 pages.
Right.
But nobody teaches everything that's in a casebook. And so what I do is once I've set up my syllabus for the year, I take that PDF, I delete all of the pages that I know I'm not going to be covering, and then I send it to the printers, and they print it out with this nice spiral binding. Yep. It ends up being, I think, around 400 to 450 pages, but we read almost all of the pages. I think Claire and Allard are in the room, but I think they can attest that they get to the end of the semester and they've basically read everything in it, which is kind of satisfying in itself. But it means you're not there aren't wasted pages here, but it can certainly be customized to different topics. If I often don't teach nuisance, but other colleagues teach nuisance, for instance, so their PDF has nuisance in it, mine doesn't.
Would other colleagues have access to the PDF though? But just you do?
Yeah. No, it's on CanLIID. You can download it straight off CanLIID.
Playing around with it, I was looking at private nuisance just because, I spend a lot of time on nuisance for reasons that my students don't understand, and sometimes I don't understand either. But I noticed that you don't have antrim in there, which is interesting, right? Because I think it's not a private nuisance case, but the Supreme Court seems to think it is. And so I just wonder, how do you deal, like my struggle as a torts professor, and I think this is that with the Supreme Court of Canada, is that they're wrong all the time. And so it's very difficult to teach tort law, the law, and then also teach the law, right? So like, how does your casebook confront that issue?
So that's great. I'm just going to reshare the page because there was a feature that I didn't that I didn't highlight, but that I think also connects up to the antrim point, if I remember what I included on private nuisance. So this other feature of the casebook, the thing that kind of actually I really liked about this was sort of motivating me to try this as an experiment, was the idea of taking a case and finding cases that deal with multiple tort issues within a single judgment and then weaving them through the casebook in a way that connects up with the hyperlinks. And so this case from BC from last year that was upheld by the BC Court of Appeal, I actually taught this case for the first time last year and then brought my class to the Court of Appeal so that we could watch the appeal hearing, which the students really enjoyed, and it was really interesting. And then we had a whole discussion in the next class about sort of what we learned from watching the appeal. It's one of these sort of classic disputes between neighbors, where there's a claim, there's counterclaims, there's so many torts involved in this case. It provides a great overview of the principles, say, of assault and battery. So we encounter it first in battery, we encounter it again in assault, we encounter it again in invasion of privacy in the context of the BC Privacy Act, and so on and so forth. And then that's legal cost. Oh, right. The legal costs became an issue as well. So there's a sort of small section on what costs are. And then a nuisance. And I'll admit, I focus less on nuisance in my own teaching right now, although the trade-offs have always have to be made. And so that's one thing that I've traded off. But I think I used Goki in part to illustrate the points from Antrim, partly for that reason. There's a big discussion in Goki, building on the case law. So what it's illustrating to the courts is how the students is how the courts are building upon and using precedent. So Antrim itself is not there, but there's extensive discussion of Antrim. And to your point, Zoe, I kind of did that for that reason. Was well, here's a case. This Go case is very much about private nuisance. It's a smoke case. It's about a neighbor who intentionally is smoking fish to make it as noxious as possible for their neighbor. Is the facts awesome that are suggested. Awesome. And so that illustrates how the principles of Antrim apply to that. So, and the idea of the Goki case is actually, it's relatively straightforward. The issues are relatively straightforward, but it's useful from a teaching perspective because the students can see, well, this is sort of a standard case. This is a less complex case. And then we have to think about, well, what about the more complex cases? What about Fern? Like, is Fern a private nuisance case? Is that invasion of privacy? Is it nothing? And so that's the idea. But I will say this has been an experiment, and I've been tweaking it and figuring out what works and what doesn't. And so I'm always open to feedback as well.
Thanks, Stephen.
So, Sam, thanks for this presentation. You and I have chatted about this previously, and I guess we'll keep talking about it as things move forward. I also commend you on the project. I mean, it really is a remarkable project. I may be the only person in this Zoom call who actually gets a commercial royalty check from a published torts casebook. So I suppose I might see myself as being the dark side to your light to some degree. And I always despair when I hear my colleagues in the same call as me claim that they want to use your product rather than the guys down the hall.
I'll still buy your book, Stephen. I'll still make my students buy your book. Don't worry.
In-house. So, but let me offer you some reactions and some thoughts. And so it's not really so much a question, but if you'll indulge me, based on 25 years of working on a commercial casebook, I'll pontificate a little bit on this. I do believe that if I were starting as an academic now, I'd be doing what you're doing and not thinking about trying to do this using commercial publishers. I mean, I really do think that the online freely available route just is the way to channel your energies. And I increasingly struggle to see what value add the commercial publishers are actually injecting into this. There was a time when they might have been able to claim that they were adding quality, right, to the product. And certainly back when I went to law school and we got photocopied collections of cut and paste extracts from like law review articles, they had a point, right? I mean, their book certainly looks more professional. It's a uniform typeface. The margins make sense. All of that kind of stuff. But desktop publishing has changed all of that, and that's at least 20 years on now. That we've had our own independent ability to produce at least a quality-looking PDF of extracts of kind of anything that's otherwise freely available for no royalty. And be able to distribute, right? So that I think very much pushes in the direction that you're going. And I think you could be doing this using any number of tech platforms, right? You're using CanLIID, you're using Wiki, but you could be producing your own in-house Adobe PDFs as well, and simply posting them on a website and making them available for download. Like there's all kinds of platforms that you could be using. So I have to say I struggle to envisage what the market for commercially sold casebooks is going to look like in, say, 10 or 15 years. I really do. And I look, I'm on several of them, and I say to my publishers, this Beswick guy is coming for you, and we got to think about this. And one of the ways, of course, I press them to think about this is, one of the easy ways, but it's so far proving very difficult, is they just got to keep their prices down, right? Like, so if my tort book costs $67, I would, there'd be very little for me to think about as to whether to make my students buy that or use your online free thing, right? I see that as a rounding error on $25,000 worth of tuition. But when my casebook is over $200 and yours is free, I do struggle with that. Like, that starts to just look like a meaningful differential that I then really have to work harder to justify. And so one salvation for the commercial people might be that they finally get wise to this as their sales start hurting and they just start dropping prices, right? They just start figuring out a way to actually produce the commercial things more cheaply. Because your print version, and I'm very glad to hear that there is a print version every year and that you have your students buy a print version every year, but your print version is not free, right? I
No.
mean, even for your Sherlock's Bound thing, they're probably paying 30 or 40 bucks.
Yeah.
Right? So there's a narrowing, right? I mean, if I could sell a commercial product at 100 bucks and your Sherlock's thing was 40
Yeah.
bucks, look, I'm still in business, right? So, but I do worry about that. Um, the other observation I have, and this is the one I'm kind of more curious about your kind of take on. Look, there are three commercial, unless I'm miscounting and have been for many years, there are three commercial products that you're competing with. Formerly Ernie's, formerly Lou and Bruce and that team, and then ours. Um, I am struck by how much astonishing convergence there has been between what I'll call Bruce's book and our book. Um, you pick up any given topic, any given area, I find it very difficult to delineate, like the extracts are very similar, the notes are very similar, the kind of queries that are thrown open are very similar. Ernie's book has been different. I have to say I haven't gone through the brand new just out Nyers
Yeah.
Essert version of that, but if they claim to have fidelity, and if they have kept the fidelity, then I assume they've kept some of those differences. But that's kind of where I want to push you, because I look at your casebook, your online casebook, and I look at your kind of developing wiki, and I would bet money, especially given the sort of student resources you have available and the fact that they are simply able to mine my product and the other product, so in other words, there's no propriety in the idea, right? But if you say, I need 15 more notes about battery, well, I know where I'd start looking, right? Like, I'd just open the commercially available casebooks and paraphrase and reshape those points, right? Which is what the commercial people have been doing to each other for years, right? Like, we just wait for the new edition of the other guy's book to come out and we go through it and we see what might have changed and what we might want to do in response to those changes, right? So you can do that in real time. You can pick up the commercial products and you can and your product as it looks now looks to me remarkably similar to what the commercial products look like. And I'll bet with kind of a large labor force and even better for you, unlimited space, right? So you don't have a publisher who's saying, I need you to bring this in at X number of pages, right? So yours can just kind of grow. My prediction kind of would be yours is going to contain most of the same content, like 80 to 90%, same kind of points, same notes, same observations, same comparative law observations as are now in the commercial books, right? And when you started this project, my knock kind of had been, oh, that's the deficiency, right? This guy's just got some extracts from cases, but he doesn't have those notes. He doesn't have all that other stuff. But all I have to do is give you time, and I think you'll have all of that, right? Your wiki will end up containing basically the same sort of footprint copy of what's in the notes of the commercial case books, and for good measure, what's in our little purple book, our introduction book, and what's in Phil Osborne's introductory book, right? Like, you're just able to take all that stuff, rework it, reorganize it, and in it goes to your online wiki. And I guess I just want, like, is that where you're thinking? Like, are you thinking like are you gonna end up because I think you are. This is my assertion, right? My assertion is I think you will end up on the trajectory you're on with a free online version of the stuff that is commercially out there now, right? And there will not be much space for somebody to say, my online project is different in a number of ways. Like the content is different. There's still reason you might go buy, Phil's book or our introductory book or whatever. I don't see that, Sam. I gotta say, I think your product is going to contain enough, like more than enough, like 80, 90% of what's in those other products that you will be able to say with a straight face, I don't see why anybody would ever buy those products again, right? Because I have, in a sense, the same content online for free.
Thanks, Stephen. Yeah, so like it's provocative, and I hope so. To answer the third point briefly, and then I'll swing back to it. I hope not, and that's not my aim. But let me go through. I took 3 points from it, right? So, first of all, the value that the commercial publishers are adding, right? And this is a struggle. If we get back to why do we have case books, right? Well, that's laying down. He wants to teach cases to students, but the cases are in the books in the libraries, and there's one copy of each book, and there's a class of 50 students or whatever. Right? You can't have it. So he creates a case book. It photocopies in, or it prints in all of the cases so that all of the students have them there, and then that's the model that's built upon into the commercial model. And then it gets expanded because then it's not just the cases, but it's the questions. Then it's not just the questions, but it's the notes and the commentary and the link, the references to many other sources that are out there, which is a fantastic resource, and it has been. The problem is the internet changed things because now the cases they're in the library, but when was the last time anybody looked at a case in the library? They're on CanLIIDocs and Bailey and NZLII and AustLII and WorldLII and IndieLII, right? They're freely available online as they should be. So if we think about, well, why did we put together the casebooks in particular? It was to solve the problem of inaccessibility to the law. We now have much better accessibility to the law. So it's only natural that I think that these projects are going to morph online. And if anything, it's surprising it's taken so long for Canadian schools to catch up. The American schools, a lot of professors have been doing this. And I think my own experience has been that the online platforms provided by CanLIIDocs and the wiki platform, so I use UBC's wiki, but it's based on Wikipedia, they're just better platforms. They're so nimble, they're so easy to use, they're so easy to work with as compared to, in my view, the platforms that the commercial publishers provide. So I think I agree. I think the motivation for the commercial publishers would hopefully be to drop prices, but I don't see this as replacing what they're doing. I certainly don't see what I'm doing as replacing what you're doing, because what I see when I open the traditional, or sort of the 3 commercial case books, is there's a comprehensiveness to them in a way that certainly the CanLIIDocs casebook isn't comprehensive. There's something between, in my view, a casebook and a textbook. And perhaps there's value there, or perhaps there's more value to them being more research textbook-like. I don't know. The problem is that the commercial textbooks, to me, they fall between, and we actually have excellent textbooks. And I'm never going to replace, and I don't see how I don't see myself replacing on an online wiki the value of those commercial textbooks. I think the commercial casebooks, I think it's a question of them deciding what they want to be. Do they want to be case readings and excerpts, or do they want to be more like textbooks? And we have an in between. But I think it's good if the commercial publishers are challenged to kind of think about, well, where's the value add? I think there can be a value add, but like that's a good thing for the market to be doing. And if anything, it's surprising that there's only one, like as far as I'm aware, mine's the only online casebook. That kind of leads to your second point, like the convergence between the surprising convergence between the 3 commercial casebooks. Okay, on the one hand, convergence isn't surprising in the sense that there are some cases you just have to teach. You have to teach the key Supreme Court of Canada case you have to teach you cannot not teach Donahue and Stevenson. In my view, you cannot not teach Palsgraf. And in fact, in my view, there are a number of classic cases that I can't not teach. And then I make a trade-off. I want to teach, for instance, Bolton and Stone, or Miller and Jackson, right? But I don't want the students to be reading the entirety of them, and so then we exert it, and I'm aware that the other case books do, right? But that's because they're classic cases. Why do they do that? Well, because the judgments refer to them, and there's something kind of self-repeating about, well, where are the judgments getting them from? Well, previous case law, and because the students learnt those judgments when they were at law school, and so there's a sort of cyclical nature to it. But I am trying, and I think I am trying to do something different from what the commercial case books offered. And part of the reason I'm trying is kind of the history story that I told at the start was like, why do this? There are resources out there, or I could just have a list of cases on CanLIID, as others often do or increasingly doing. And there are a couple of themes that I do take seriously and want to be reflected. Not to say that these themes represent an ideal system of law, but to think about how we should think about the law through these lenses, and whether or not, for instance, equality under the law really is being affected. And so my selection of battery cases, I don't think, for instance, Benzaris is a key battery case in the other case books. Certainly, I teach a case from the Supreme Court of India called Kohli about a woman who went in for a routine I can't say the word lescoprisy, just as a keyhole surgery, just to investigate a problem. And while she was under, the doctor, without her consent, performed a hysterectomy on her. And so, and it's a remarkable case for a couple of reasons from a teaching perspective. One is it illustrates sort of the breadth and seriousness of the tort of battery, as well as the relationship to the tort of negligence. But also in the discussion of informed consent, the Supreme Court of India refers to the Bolam test and considers the test by this and rebuild from the Supreme Court of Canada, and considers a mirror that I try to show is this idea of this conversation of the common law across jurisdictions. And I guarantee no commercial casebook in Canada is teaching the Kohli case from the Supreme Court of India in 2008. So partly in my selection of cases, and partly in my approach of trying to select cases where you follow the case through a journey. The Kohli case appears in about 4 different sections of the case book. And so on the one hand, it's self-contained in each section, but on another, you get a broader view as you encounter it in battery and then re-encounter it when you're learning about informed consent to negligence. So in that sense, I don't want my casebook to converge with others. And then, of course, just in the layout, being in 2 separate platforms, I don't see it as just a straight convergence, but I recognize, like, on breach of duty of care, right? Well, there are just classic cases that you just have to be taught, right? You have to teach Ryan and Victoria. You have to teach Saskatchewan wheat pool, and I think it's a problem if you don't. But they're going to be in all the case books. And then the third point, right, is fine. Maybe it looks different now, but give it 10 years, throw enough resources at it, and it will suck up everything and replicate everything. I don't want it to do that. The idea of the wiki, one of the instructions on the wiki was keep it brief. The wiki, again, I don't envisage it as a textbook. I want students, I coach a moot. I am shocked every year when the students come with their research and they have not been in the library and gotten books. I want them to go to the books. There's some things that only books can do, setting out detailed, comprehensive research and journal articles. I'm not trying to do that with the wiki. I see the wiki more like a hornbook, maybe more like your purple book in that sense. So maybe like that, right? But
yes, I don't mean to interrupt, but just to be clear, I was never suggesting you're going to take over the treaties space.
Yeah, okay.
I was suggesting that it's the purple book and the Irwin Essentials book,
right,
that are very much at threat from what you're doing in your wiki. I don't lose any sleep that you're going to replicate the enormous Bible that was Friedman.
Yes, yeah, exactly. And if anything, if I can, I mean, I Friedman is such a it's such a different resource, right? So maybe, but there's more than 3 horn books. There's 4 or 5. Again, I'm not. I think they do different things. Maybe they have different perspectives. I do not want the wiki pages to get too lengthy. I want them to be digestible. I see this as a teaching resource. I want students to be able to sort of do their readings and then think, I didn't really understand that, and then go to a page and review it and be like, okay, that gives a bit more context, and then come to class ready to talk. And maybe I see it as I also see it as sort of a springboard for research, right? I had a student recently, they want to write about punitive damages. I said, well, great. I mean, you can't just write about punitive damages. We need to focus and find a problem. So go find a problem. And you might want to start by checking out these resources that are linked here and reading those articles. And so in that sense, it's a research platform, but not because it has the research in it, but because it links back to the research, which I think is a real advantage of the online platform, rather than that a physical textbook just can't achieve, because you can't, at the click of a button, find yourself on SSRN or some other repository.
Thank you. And Doug next.
Hello, everybody. I'm the interloper here. I'm Sam's colleague at UBC, and not a torts law, property law prof, but very interested in the casebook. And Stephen, just to follow up some of your comments, I've been involved for many years on a commercial casebook, and I would absolutely start in the open access realm if I were starting now. Sort of feel like I'm stuck with copyright. And if we just back away, then somebody else will pick up all that work and do it. I'm sort of wanting to move away, but sort of feel like I can't because among other things, right, there's no formatting advantage with a commercial publisher. There's no distribution advantage anymore. In fact, it's just a headache, the distribution piece. There's no advertising or prestige advantage anymore, so the advantages are gone. And Sam, what you've laid out, among other things, which are much more difficult with the commercial publisher, is the capacity to update. You're sort of locked in for 4 years or whatever the cycle, and the flexibility to say, well, actually, I want these 6 chapters, but not those 4. Again, you got to buy the whole book or not. So there's so many advantages in doing what you've done. So good on you, and really nice to see. The other point. About the sort of the substantive differences between different products. I'm always struck when I look south of the border, and right, so in the Canadian context, there are 2 or 3 casebooks in any one subject area. In the US, there's 12 or 14, and each have very different approaches, right? Theoretical approaches. You can find your law and economics approach. You can find your critical theory approach. You can find your doctrinal approach. Also very different pedagogical approaches. You can find, right, the Socratic approach to problem-based learning. You can see the practice-oriented. So there's just a range of options there, and that's also something that, right, that we interesting, Stephen, to hear your comments about convergence, which in a way is a real pity if that's the case, right? That the range of options is much more interesting and appealing. But Sam, my question for you is so in a sense, what you've done is quite traditional in that you've put the primary sources in one place, the casebook, and then the commentary in another place, the textbook. Although it's not a textbook, although it's sort of, I was thinking this is sort of an odd combination of additional teaching resources, of student cans, summaries, and really useful. But the principal difference, I mean, what's the power of a wiki? It's collaborative, right? That's the key difference. And I just want to hear a little bit more about that collaborative piece, right? So you could do it with just a web page, all that stuff up there, but you haven't. You've done it as a wiki. What's a wiki? It's a space to collaborate with somebody performing some limited curatorial role, or at least that's the Wikipedia model. And so just want to hear a little bit more about that collaborative piece with the wiki.
Yeah, thanks, Doug. That's right. And so this wiki in particular, it's kind of it's sort of an in-between in that sense, because it's hosted on UBC Wiki, which means in order to edit it, it can't be edited by anyone in the world. You have to edit it if you've got a UBC login account, which everyone affiliated with UBC does have. And if there are professors out there that want to make amendments and want to get involved with this, I'd actually be quite happy for them to get in touch with me, and you can get sort of temporary accounts. But it does provide me as the sort of overall editor a level of kind of control and partly to Stephen's point, to make sure that the wiki doesn't just cover everything or sort of converge in a way that that I hope it doesn't. And it is collaborative, right? This was funded by a grant to hire students. I hired 6 excellent students over 2 summers. We met once a week. We kind of divvied things out. We'd work through the pages. Claire, who's here, was really instrumental actually in the design side of things. She designed I believe, right, Claire, you designed the side panel. That was the first thing we had to figure out was, okay, we have this wiki. How are people going to navigate it? And so we went through a couple of different iterations, and the students really helped, did a lot to help me kind of figure that out. And then we've got a really great support team with the Centre for Teaching and Learning here as well that helped the technical side of things. So it was collaborative, and that's kind of, that makes up for what we're not getting. We're not getting a professional editor from a journal, but if anything, it's kind of, I'm getting the assistance on the technical side that I wouldn't ordinarily. And then over those 2 summers, I'd meet regularly with the students. We'd review the pages, we'd edit. I then kind of went through each page and sort of tidied up or reviewed or edited or went through as well. So I get that balance. But where I see this heading is there are some pages that are quite kind of rudimentary, or that sort of we didn't have a lot of time to go into a lot of detail on, or that I want to build up. And I envisage sort of potentially in an upper year seminar at some point, maybe that's part of the project, is that, all right, now we're going to sort of, each student is going to work on a particular page of their interest, for instance, or I'm not sure. I haven't thought that far ahead, but I can see how the idea was supposed to integrate student contribution, student learning, and kind of, and then refinement between myself and other professors and the students to sort of build that up. But in that sense, I want it to be collaborative, but I am kind of, there's that level of control that you have as an editor, as opposed to it being, say, on Wikibooks, where it might just turn into something quite different. And I kind of don't want it to turn it. I want it to be, I think a really significant feature of it is Hilary Young's podcasts are there, that she, like her great podcast on goodness, what's it called? Stereo Decisis, right? Talking about the harassment cases, right? That's out there already. I've got it on my podcast thing on my phone. But now you can just go to that page and say, oh, look, Professor Young at UNB is talking about this case that we learned in class. And so that's actually where I see the value add, not so much in replicating content that the other books have, but like in bringing content together and then making it a springboard into people's SSRN articles, into sort of interesting blog pieces, sort of other things that aren't often captured in the traditional case books or in the traditional resources in the same way. Yeah.
Thanks, Doug. So if another question, Sam, I'll insert my for the final question. I think I actually had 2. One of them, I think I could frame. So I see the project as, in a way, it just reminds me of some work I did as a research lawyer in a litigation firm, and there the research lawyers were kind of teamed up with knowledge management within the law firm. And knowledge management is like librarians, but also people who are procuring things like Westlaw and Quick Law, these kind of legal research tools as well. One thing we did behind the scenes was, like, the medical malpractice team really wanted a kind of summary of, relevant principles that apply to their area of law. The public law group wanted one for judicial reviews and so on. So we'd make like something that to me resembled one of the pages on the wiki, a one-stop shop with links that they can go and the lawyers within the firm can go and look for further. The thing is, we had a very explicit disclaimer to say like this is not a substitute for going and reading the cases
Yeah,
yourself,
yeah,
right? And now you see this case, is it the Co case about hallucinated. I'm not sure if you've seen this, but it is something going around the legal research community where
oh yeah,
I think Justice Myers and the Ontario Superior Court like said a factum was submitted. It's pretty clear these cases didn't exist; they were just generated by ChatGPT.
yeah,
And cited the lawyer in contempt, right?
yeah,
So part like there's this, it's not that you're not using AI, but you are using new forms of technology, and I guess there's a worry in the professional community about that becoming a substitute for lawyers doing their own work. Now, yours is pedagogical. And so you mentioned a bit like you don't want this to be a substitute for students. Like the wiki shouldn't be a substitute for going to.
don't cite the wiki. Yeah,
Right. So then, but like I think there is a real, I don't know if it's a worry or just an anticipation that students will do that. And I'm not even saying that's a bad thing in itself. I actually not because students are kind of cheating or anything like that, but because students are very busy and they've got a whole bunch of courses where they're doing this sort of thing, plus whatever other things they have going on in their lives or in their extracurricular work, right? So it's like, is that a worry that you might have? In particular, because just like the legal research work that I remember doing, I think as a law student, to prepare for exams, we prepared at Osgood, we prepared for them by preparing summaries. And
yeah,
the summaries look like, going into the casebook and building up something that ends up looking like the wiki, including like, here's the steps of the test. Here's like
yeah,
a really one-liner about the facts in Donahue and Stevenson or whatever. And maybe even doing some supplementing by looking at whatever else is on the internet, really. And is there a worry or should this be a worry even about it becoming a substitute for students doing that sort of work?
yeah,
So that's one. And my other question is just about tort law and social equality.
yeah,
Um, I think once upon a time there was a kind of idea to create a case book on tort law and social equality out of the project. And I think one question here that I have, and maybe you've thought about this, is like, is it a separate case book when we're thinking about integrating issues of social equality into the torts curriculum? Or it seems like you have it kind of peppered throughout the commentary and the case law. And that's a second approach. A third approach is to say there's a specific section within the tort law book. And that I think you've combined the second and third because you have that under the tort theory component. Maybe you have something on like you have the thing on discrimination, you have the part on charter damages, right? And the influence between public and private law there. So
yeah.
then I just general reflections on integrating social justice within the curriculum and those different approaches.
Yeah, thanks, Anthony. So the first point, so there is a disclaimer on the front page of the wiki, and the disclaimer says something like, this is not legal advice, and this is not really a resource you should be citing. I really emphasize when I'm working with the students, when I'm putting together my own materials, everything should be linking back to its original source, right? So if you go to the case book, every excerpt, every judgment, everything kind of often has sort of two links back to where you can actually find it, and it's all cited. And the idea is partly on the wiki also to demonstrate to students the importance of citing your references. And certainly, I don't want anybody citing the wiki, right? You shouldn't. I'm sure students are learning. They must be learning in high school, right? Don't cite to Wikipedia, right? Go cite to the sources. Go to the sources that Wikipedia is providing. So yeah, the AI hallucination thing is a problem, but I think the solution is make the sources readily available, right? And a hyperlink does that in a way that just having a reference there isn't. The reason these happen is because like, well, who wants to go to the trouble of looking up the case? But it's so easy now. The case is right there. The definition of the tort's right there. You can just click on it. So I think that's kind of that's what I'm trying to do with it. No worries. Sorry. It should not replace CAN. So one thing that I emphasize to my students, and my students often learn after their December safety exams, is that if you use somebody else's notes to prepare for the exam, you're probably not going to do very well in the exam. And I also teach in a very Socratic way. Now that might just be me, but if you turn up to class, right, it might be all well and good that you got all the notes there, but if you haven't understood them and read them, then you're going to struggle to answer the questions. So then you're not really learning. I don't think this will replace CANs for the same reason that I think using someone else's notes is not a good substitute for doing your own research. It's that actually making your own notes is the best tool that you have available to you to actually learning the content. It's the process of writing them out yourself that helps you to learn, not just passively reading what someone else has done. But I think this makes it more accessible for people to be able to figure out how would I put my notes together. So if it does that, then that's good. And then, like, where's the social equality in all of this tort law? I think and hope that it's peppered through. It's kind of, I mean, what do we mean by social equality as well, right? But like, we in some sense, it is all the way through all torts curriculum, right? When we're talking about Wilkinson and Downton, right? There's a lot. There are feminist perspectives. There's a lot of kind of social perspective going on in that case that brings to bear as to why it's why it's significant that the court recognized the tort in that case in the way that it did and the limitations that it placed on it, that can be unpacked and traced through that topic. Maybe some topics are more obviously related to the theme of tort law and social equality. But certainly by the time kind of halfway through the course, I do a class on tort theory, right? And again, in 50 minutes, I try to cover 10 theories of tort law. But the idea is I ask the students, okay, so like, here's a brief, like, what themes have resonated with you as you've been reading the cases, right? And invariably people will bring up certain cases to say, well, that seems like there's a feminist perspective being recognized here, or that seems like that there was something else going on in that case that wasn't just that critical perspectives might help us to shed light on, like who the parties were, what was, how did that case even get to court, for instance. So the idea is it's peppered through. But then there will also be sections where maybe it's emphasized a little bit more, certainly, in the tort theory section, for instance, and in other sections dealing with often quite difficult subject matter. Yeah.
Okay, great. So Stephen, one more. We're out of time now. Are we going to be
one more?
Are we going to be able to do it really quickly, or
yeah? Just to push back a little bit. And it's counter to my interest, but I'm a little, I mean, I would have thought one of the things you would want, one of the gulfs you'd be wanting to try to cross is how to make it acceptable, not even just for students, but for judges and courts to cite your wiki, right? I mean, I don't write the little book just for students as a tool to learn the law. I write the little book also as a primer for judges and courts. And I think it would be a big disservice on my part if I thought, yeah, I wrote this and it's a book and it's out there, but nobody should ever rely on it as though it was an actual secondary source, right? It freaking is a secondary source and it gets cited, right? And so to some degree, you're limiting your own project on the wiki side if you don't think that could ever rise to the level of a secondary source. And let me just add a further piece to that, right? Which you keep saying, oh, well, but you can always go back to the original. You can always, the wiki just takes you back to with a footnote to the original. Well, no, okay. One of the great benefits of writing texts, even smaller texts, is that in a couple of well-chosen sentences, the author can get their point or perspective across on a development or on an issue, right? Without having to publish a 30-page law review article. And ideally, you want that citable, right? So, I mean, I want the Supreme Court of Canada to be able to say, in commenting on the Court of Appeal's earlier decision, Patel said the following, and even if he said it in a wiki version rather than a published print version, if you've done it right, you want that to equally be taken as citable, right? Like you don't want to limit yourself, and there's no backup to that. There's no footnote on the wiki that's just you commenting in what you're distributing. And I would want you to aspire to want people to treat that as citable, right? So when you say categorically, I don't want anybody citing my wiki,
okay,
I worry you're really limiting yourself in that respect.
Yeah, thanks, Stephen. That's that's encouraging. I mean, maybe I'll think, I guess my own thought of what it is as well has been evolving, as it started as this, just as an idea and as an experiment to see what we could make. And so, like, we all like to be cited, like that would be great. I guess I'll say I didn't put it together with that in mind. I put it together as a way to think about, well, how do we cover kind of, again, like a hornbook, how do we condense something, but make it I really do see it as that springboard into other resources. And in that sense, a kind of a springboard for when students want to do research papers, like, where's a problem, right? Where's something you disagree with? Like, and then like you can very directly kind of find your way into a starting point for research through it. I guess my hesitation around citing it is that I expect it to change, and kind of maybe it won't change as much because I get busy, and it'll probably be reasonably stable for the foreseeable future. But it's kind of I go through refinements, but it is less stable than a book. It doesn't have editions. It doesn't have defined authors as such, or chapter authors. It is collaborative, and so maybe that's not a problem. And I think it's doing something useful for what it's doing, and if others find it useful, maybe it should be cited. But I suppose just the context was that wasn't the mission on this one. But if anybody is interested in citing me, they can go to my SSRN page and go nuts. Please do. But thank you for all turning up for this presentation. It's been a real treat for me.
And the wiki be widely cited by all.
Thanks anyway.
Thanks everybody, and thanks Sam. Thanks everybody for coming out
Sam.
to final session.
Thank you. Bye.